Hello, I'm Rashi GOEL and I'm legal intern at LEXIS and Company. In this video, I'll be talking about the essential of a valid will and its revocation. So first, let's talk about what is will. According to Section 2, Clause H of the Indian Succession Act 1925, a will or a testament is a legal declaration of the intention of a person when he wants to distribute his estate as a testator to the people who would be inheriting the estate after his death. It is to be duly noted that the testator cannot include any property in his will which is a joint family property or ancestral property. So now the question arises, who can make a will? According to Section 59 of the Indian Succession Act 1925, a will can be made by any person who attains the majority at the age of 18 years. And a person must not be mentally challenged, but if a person who at the time of making the will is mentally sound, that will shall be valid in the eyes of law. A will can be made at any time in the life of a person. A will can be changed a number of times and there is no legal restriction as to the number of times it can be changed. It can be withdrawn at any time during the lifetime of a person making the will. A will has to be attested by two or more testimonies who have seen the testator signing the will. So now let's talk about the essentials of a valid will. First is legal declaration. The document purporting to be a will or a testament must be legal, that is, in conformity with the law, and must be exempted by the person legally contempt to make it. Further, the declaration of intention must be with respect to the testator's property, which is illegal document which is binding force upon the family. Now, the second is disposition of property. In a will, the testator bequeaths or leave his property to the person or the people he chooses to leave his assets or belongings. A Hindu person may, by the way of his will, can bequeath all his property. However, a member of an undivided family cannot bequeath his co-partner interest in the family property. Third condition is take effect after death. The will is enforceable only after the death of the testator. And under Section 18 of the Registration Act, the registration of a will is not compulsory. Also, Supreme Court in Naren Singh versus Kamla Devi has held that the mere non-registration of will cannot be drawn against the genuineness of the will. However, it is advisable to register it as it provides strong legal evidence about the validity of the will. Also, once a will is registered, it is placed under the safe custody of the registrar and therefore it cannot be tampered, destroyed or mutilated. It is also released only to the testator himself or after him to an authorized person who produces the death certificate. Since a testamentary disposition always speaks for the grave of the testator, the required standard of proof is very high. The initial burden of proof is always on the person who propounds the will. Last is revocability. Section 62 of Indian Succession Act deals with the characteristics of will, which is being revocable or altered any time during the lifetime of the testator. Section 70 of the Indian Succession Act provides the manner in which it can be revoked. A mere intention to revoke is not an effective revocation. The revocation of will should be in writing and an express revocation clause would revoke all the prior wills. If there is no express clause to the effect, then the formal will would become valid to the extent of its inconsistency with the latest will. So, this is known as the implied revocation. However, if there is no inconsistency between the wills, then they cannot be considered as two separate wills. But two must be read together to indicate the testamentary intention of the testator. Revocation can also be made in writing through declaring an intention to revoke, and writing must be signed by the testator in the presence of two testimonies. The deed of revocation has also been executed in the same way as the will itself. The will may be burnt or torn by the testator or by some other person in his presence and by his direction with the intention of revoking the same. The burning of will must be actual, not symbolic. The burning of will must destroy the will at least the extent of his entirety. Further, the will need not to be torn into pieces. It would be sufficient if it is slightly torn with the intent of revocation. The will can be revoked expressly by another will, or by implied revocation, by some writing, by burning or tearing, or by destroying the otherwise. Cancellation of will by drawing lines across it is not a mode of revocation. Under the Hindu law, the will is not revoked by marriage or by subsequent birth. Thank you.